Imagine you're looking for inspiration on YouTube for new content ideas and you come across a new music video that you want to review. You know your Instagram audience will love it and you'll get tons of engagement. But you're not sure how to deal with the copyright-related issues. In this video, we explain some of the new changes in the amendment to the South African Copyright Act and how these changes affect you. To catch you up, let's take it back to the beginning. What is IP? IP is the intellectual property of anybody that creates from a basis of knowledge and know-how. There are different kinds of IP, for example, patents for new inventions, trademarks like the most recognizable logos, the trade secret behind that chicken recipe. The expression of ideas is protected by copyright. In South Africa, this legislation is the Copyright Act of 1978. Anything from music, stories, apps, theatre plays to digital content and film are protected by copyright. For example, when you make a film with your own money and resources, you own the copyright to that film. You can decide to license that film to online platforms and earn licensing fees or royalties. Royalties are payments made to you as copyright holder for the right to use your copyright. When your music is streamed on Apple or Tidal, or you hear your song on the radio, you earn royalties. Royalties are collected on behalf of artists by collection agencies like Samro, Sampra, and Capasso. Fast forward to 2017. The Department of Trade and Industry proposed an amendment to South African copyright law. Some of the key changes proposed by the new amended copyright bill are: when a creative is commissioned to produce specific work, there needs to be a contract clearly stating how the royalties will be treated. A creator of visual artwork could claim resale royalties if the work created has been resold. This means you would earn a resale royalty based on a secondary sale of the artwork. A creator would never be able to sign off or sell their royalty rights, but only sell their copyright. The Copyright Act of 1978 has a clause called fair dealing, which allows a limited list of uses like educational purposes where copyright could be used without infringing on the rights of the copyright holder. The new amended bill introduces a new concept called fair use. Fair use is an open list of exceptions to copyright practices that replaces fair dealing. For example, if a documentary maker wishes to use red carpet footage for a documentary, they could approach the copyright holder for permission to use the red carpet footage. The copyright holder could charge the documentary maker a royalty fee or give permission to freely use that footage. Now imagine the same documentary maker needed footage from a successful film like Matwetwe, and the filmmaker had no way of reaching the copyright holder. Under fair use, the documentary maker could justify a scene from Matwetwe and not pay a royalty fee to the copyright holder. To successfully justify fair use, the documentary filmmaker would need to show 1. Their work is a documentary and different in nature to the film Matwetwe. 2. The scene taken from Matwetwe is not being overly used and not the main focus of the scene in the documentary. 3. The documentary film will have an education audience different to the film Matwetwe. 4. There is no one who would look for the documentary first if they wanted to see that scene from Matwetwe. So what can you do to protect your copyright interests? Send an email with the content in PDF to yourself to show ownership of creative work, as the email shows date and timestamps. Watermark your work before sending it to others. Register with the relevant collection agencies when relevant. Be an active member of your industry by voicing your opinions as laws change. No one knows when the bill may be signed by the President. It may go back to Parliament for revision, and you need to be ready for this. We will keep you updated if anything changes. Until then, you can find us